All right, good morning, everyone. Good afternoon, depends on what time you're watching this video. We are here with Arizona Attorneys Respond, specifically during the COVID pandemic. My name is Alberto Rodriguez, and I work at the State Bar of Arizona. And I have two lovely volunteers with us today who will be talking about wills and trusts and why it's important to be prepared, specifically during this time of unrest, right? We didn't realize that this pandemic would cause such a frenzy. Didn't realize that there would be so many deaths associated with it. So we brought on Chelsea Hesla and Ashley Case from TIffany and Bosco. They're going to answer all the questions that you submitted via social media. And if you have any questions at the end of this video, let us know and we'll try to get them answered for you as well. So Ashley, Chelsea, thank you both for being here today. Truly appreciate it. This is, again, a service that we are providing for the public. There's some unrest, uneasiness, and we're doing it here virtual style to maintain that social distancing. So welcome, ladies.
Thank you. Thank you so much for having us.
No problem. Thanks for being here. So we'll go ahead and start with a question for Ashley. Ashley, this is something that was submitted online. Is a handwritten will valid? Actually, you know what? Before we get into the details of each of the questions, can we talk about the difference between a will and a trust?
Absolutely. So the way I typically think of a will is that it's a testamentary document. So it really doesn't do a whole lot for you until you actually pass away. And its primary purpose is to immediately distribute assets. So as soon as possible, we're trying to get those assets to our beneficiaries. What that means for minor children is that under a will that they are entitled to their full inheritance upon turning age 18. So as soon as they reach the age of majority, they get everything outright. Now, a trust is a little bit different. A trust is a living document, so it can do things for you while you're still alive. Your trustee may be able to manage your asset in the event of your incapacity. And then we can also place some more controls over our beneficiaries. So in the case of minor children, we can step distributions out until they're a little bit older. So that can be a big help within the trust. And then the primary difference between them as well is the idea of probate. So in Arizona, we have a probate threshold of $75,000. So if you have assets that are in your name alone and do not have a beneficiary associated with them, the state says that it wants to be involved in the process of making that distribution happen. And we do that through the probate process. So depending upon how complex the estate is, sometimes that just means filing a whole bunch of paperwork with the court. Sometimes that can mean actually having to appear in court and having an attorney represent you, things like that. But with a properly executed trust, we can potentially avoid the probate process entirely. Things flow directly from your trust to your beneficiaries, and we don't have to worry about that probate process.
Gotcha. Now here's a question that a lot of people have. Do you have to have a lot of money to have a will? I mean, because you're talking about beneficiaries and your child turning 18 and then getting, taking advantage of it. But, I think that's a concern of some folks. Does having money mean you have to have a will?
That's a great question, and I get that a lot. I think a lot of us are kind of in tune to the term trust. We think of somebody who is maybe a trust fund baby or, has an enormous amount of wealth. And yes, it's important for people who are in that position. But for people who have more modest net worth, it can still be of benefit. That primary reason being minor children. A lot of times we want to step the distributions out for a child to receive an entire inheritance at age 18 can be a little bit dangerous. And then avoiding that probate process is helpful as well. That can be debilitating to a modest estate. If we have to go through an entire probate process in order to distribute assets, that administration can really cut into the assets that are available ultimately to the beneficiary.
Gotcha. Thanks for that, Ashley. We'll go ahead and ask Chelsea a question. So just kind of piggybacking off of that, Chelsea, if I was listed in a will and I never received any assets, liquid or otherwise, what are my rights? So somebody was already named in a will, which Ashley alluded to, at least 18 years old. What are my rights receiving those assets?
We certainly do have some rights. If you have, if you're listed in a will, it's called a devisee, but for sake of easy reference, we'll just call it a beneficiary. You're going to get something under the will. And in that instance, the first thing that comes to mind is you'd want to see, is the will actually being administered? Is somebody out there, what we call the personal representative, making decisions pursuant to the will, or carrying out the will's terms, distributing property, distributing assets, making decisions, or carrying out decisions rather. That person's called the personal representative, and that's typically the first step in opening up a probate, or in like what Ashley was talking about, in instances where a probate is not necessary, there still should be somebody, usually who's nominated under the terms of the will, to carry out the testator's intent. And so that would be my first suggestion, would be to look and see who's responsible for administering this will. And that's really who you should be talking to. The personal representative has fiduciary obligations that they owe to you as a beneficiary. And so that's who you'll want to reach out to. Typically, a probate should be opened within 2 years. And so if you're looking at a period of time beyond that, we do still have what we call tardy probates. Some additional considerations and whatnot. But ultimately, the first step should be to reach out to that personal representative and follow up with them.
Gotcha. That's great information. So a lot of the folks that have submitted questions, this is all new territory to them. So I wonder if we can, you guys are the experts here, right? And I wonder if we can answer questions that are a little less technical. And believe me, I know it's important for them to know the nuances, but I think one of the cool things that I've learned in the past, especially working at the state bar and working with consumers, is if we can talk to the folks, like trying to explain it to like your 80-year-old grandmother, you know what I mean? So it takes a little bit softer language, but this is so technical. So I get where you guys are going with this. I just want folks to understand within this video. So thank you for that. So we're going to go back to Ashley. Ashley, is a handwritten will valid? And if so, can I amend it in handwriting again?
Sure. So in Arizona, we refer to that as a holographic will, and we're one of a number of states that permits that. And the threshold is pretty low. So if you're wanting to create your own will, the requirements are that you sign it and that the material provisions of that will are included within the document. Now, where it gets a little bit hairy is that, unfortunately, when we do a holographic will, it can open up some questions. Did you intend, first of all, is it really your handwriting? If we don't have a witness, how do we know that it was you who created it? Were you under any duress or undue influence when that happened? So yes, we can absolutely do a handwritten will. Not always recommended. Usually we prefer that we have it properly executed. So if that's something that you're able to do, that would be preferred. But the nice thing is that the law does allow for us to do that. So if you're in an emergency situation, you don't have anything and all you've got is a piece of paper and a pen, at least in Arizona, we'll let you do that. To your question about, oh, I'm sorry.
I was just gonna say that I heard, that you can write your will on a napkin and it could be valid. That's interesting.
As long as it's signed by you and we've got those material provisions in there, we have a will under Arizona law. To your second question about amending it, you can create a new document. That's typically the easiest way of doing something. So when we have a new will, a new date that shows that it's a later created document, that makes it easier. You can also revoke through what we call a revocatory act. So that would mean burning, tearing, ripping, otherwise destroying that document that you had before, which indicates to us that you no longer wish that to be your valid document.
Gotcha. Yeah, I first heard that a few years ago where they said, yeah, you can write your last wishes on a piece of napkin, and in Arizona, it would be considered valid. So that's very interesting, and it's good for folks to know, because I think that this is such a heavy topic that it's confusing, although that's probably not the route that we want them to go, right? We want them to be a little bit more prepared than not.
Right.
Let's see, what's our next question? So Ashley, real quick, piggybacking off of that, does your location have anything to do with the edits or the changes that you make to your will, or its validity? So if I change address, doctor, I come from a different state, do I have to update the will? So I kind of all those moving parts that if people move, what does that do to the effectiveness of a will?
So certainly from a clarity standpoint, if it's possible for you to update those documents, I think it's wise to do so, because then there's no confusion about the people you intended to be a part of your estate, where they're located, how to get a hold of them, things like that. But the law recognizes that people change, people move and accumulate new addresses and phone numbers. So that's certainly allowed. When it comes to a healthcare power of attorney, which I think we'll talk about probably in a moment, you can actually amend that document if you are only changing the address or phone number. Very simple for you to change it. But if you're going to actually change the people who are involved, so now we're creating totally new agents, or you want new physicians to be involved, then we have to go through an actual formal document. So we need to create a brand new document that expresses those changes.
Gotcha. And speaking of changes, what if somebody passes and questions the validity of a will or a trust? Kelsey, is this something that's kind of up your alley in terms of I don't trust that my sister made the right decision or my stepmom made the right decision, and I want to challenge what's written in the will or the trust? Is that open a can of worms?
It certainly can open a can of worms. There are ways to challenge the validity of estate documents. One of the most common that we see in Arizona is undue influence. And under Arizona law, if a trust or a will was established because of undue influence, then it can be invalidated, meaning it's no good and the court just tosses it out. Now, that does require court intervention. And when we use the term undue influence, I want to kind of clarify that not all influence is improper or bad. It's just really when it rises to that next level of being such a great amount of influence that the person whose will, let's say it is, they're not even reflecting their own wishes anymore. They're actually just going after, doing what they're directed to do by the influencer. And so when it rises to that level, yes, a will or a trust can be invalidated by going through the courts. And the court's going to look at a lot of different factors. In Arizona, we have specific statutes and case law that tell us what types of things that we need to look at to determine if an instrument was prepared under undue influence. And the types of things that the court will look at are things like, did the influencer lie to try and induce someone to sign a document? Did the influencer benefit personally themselves from these changes? Was this consistent with the plans that the individual had before? Let's say they had multiple prior versions, or they'd expressed their wishes in other capacities. Another thing that the courts look closely at, and this is something really important for people to keep in mind right now, as they may be, a lot of people are thinking right now about making their estate plans and developing plans in light of all the uncertainty that's going on. And so one of those elements that the court will look at is, what is the relationship between the influencer and the person whose will or trust this is? And so if it's a close family member or a caretaker or one of these close confidential relationships, there can be presumptions under the law of an undue influence situation. And so if you are going to be assisting a loved one right now with preparing something like a trust or some type of estate plan, a will, I would, just as a cautionary note, make sure you're being careful, because you'd hate to be in a position later on where you're accused of unduly influencing somebody. And ultimately, we all just want our loved ones, best wishes to be carried out, or their last wishes to be carried out. So some little nuances there, but the point is that it's a very case-specific analysis that the court will do, and they'll look at a lot of different factors, but it'll be different in every single case.
Okay, good. So this is kind of a sidebar question. Does that happen pretty often? Are wills and trusts and estate plans, are they questioned? Like, is that something that's, it's every blue, once in a blue moon, or does that happen for pretty frequently?
Unfortunately, we do see quite a bit of it, especially in Arizona, because we have a very large vulnerable population, or a lot of people enjoy their retirement here in Arizona, and so frequently they'll be executing those types of documents at that stage of life. We see it more than we'd like to, of course, and it's, these areas are not always so black and white, because there's a lot of good intentioned people out there who really are trying to assist their loved ones, and they just have to be careful about how you do that. Certainly there are ways to assist those that you care about, where you're not going to be creating claims such as undue influence, but it's certainly something to be aware of, because yes, unfortunately we do see quite a few of these claims, but at the same time it is important, because when we're dealing with particularly a vulnerable population, and these undue influence claims often arise when somebody is more susceptible, of course, to undue influence. They're sick, or they have some type of mental or physical disability that would make them more susceptible to that type of influence.
Gotcha. And Ashley, with again, working at the state bar, you kind of learn all these new, I'm not a lawyer, I do the communications, but I learned the importance of having something set up if you're a parent. And it doesn't matter if you are 19, it doesn't matter if you become a parent at 40, because of untimely death of a parent or parents, because it does put your children in the lurch. So it doesn't matter if you have money, but you want to make sure that your kids are being cared for, as you would want to. So let's talk about that, about that aspect of taking care of your kids.
Sure. So one of the major parts of a will, in the event that you have one and you have young children, is that's where you will be appointing a guardian for them. So I'm a mom myself. I've got 3 kiddos, and I can tell you from firsthand experience, I don't think that there's anyone else on the planet who will make a better parent than you, but you probably want to have some say in who that person will ultimately be. So within your will document, you're able to provide choices for who you want to serve as their guardian in the event that happens, as well as backups. So if your first choice isn't available, you can name a second or a third choice as well. That helps to avoid the court process that would otherwise be involved in appointing a guardian for them, and kind of makes it easier on everyone, because we know what the wishes are. There's nothing to argue about, because it's kind of set right in stone in that document.
Gotcha. What about a medical power of attorney?
Those are great. And I would say, especially in this time and everything that we're dealing with, at an absolute minimum, everyone should have a medical power of attorney. What that allows you to do is appoint somebody else to make medical decisions for you in the event that you're unable to make them for yourself. So physicians will always try to communicate with you if they can get you to write something down, or blink or do something that will let them know what your wishes are. They're going to go with that. But in the instance where they're not able to communicate with you and a decision needs to be made, it's helpful to have an agent who you've appointed who can immediately step into that role. Within your healthcare power of attorney document, you should also have what's called a HIPAA release. So HIPAA stands for the Health Insurance Portability and Accountability Act. And what that does is it prevents medical providers from releasing your medical information to anyone but you. That includes your spouse, your immediate family. They can't tell them anything about what's going on with you without your consent. So if your power of attorney includes that language, that allows whoever you're appointing as an agent to kind of have those free conversations with medical providers. They get information about what's going on with you, your medical history, decisions that need to be made, maybe weighing the pros and the cons of what needs to happen. And in an emergency situation where somebody has to make those decisions for you, that information is really valuable.
Absolutely. So one more question for Ashley, and then we'll have Chelsea follow up, because it's now we're getting into a little more of the the trust side of things. So I'm interested. Question was, I'm interested in setting up a living trust. How do I start, and what does that entail?
So I would recommend talking to an attorney. Our Arizona Trust Code is expansive. There's a lot of information in there. There are a lot of particular pieces that need to be included within your trust for it to be valid. So what you'll want to do is meet with an attorney. I'm currently doing online meetings, and I know a lot of other attorneys who are also estate planning attorneys are doing the same. So typically that first meeting would be just kind of talking about you, finding out a little bit more about your assets, your family, what your wishes are, going through that process with you so that they can start to pull together a draft of your actual documents.
Okay. And what does a living trust entail? Like, I know that, what can you maybe name 5 things that someone should get prepared in order to make this happen? So if you're giving a client a list of the 5 most important things, or maybe there's not that many, to gather and bring to your office so you can get them prepared, what are some of those things you should consider?
Sure. So I'll take basic, contact information, kind of information about, your address, your phone number, email, all those sorts of things. So that's helpful to have. Family. Who are the people who are part of your family, and then kind of how do you feel about them? So it's important to know that you have children, that you have parents, that you have siblings, but also if you've got kind of a funny relationship with them right now, and maybe you've got a brother who you don't want to be a part of your estate, that's very important to know. So understanding that familial relationship. Assets, that's a big one for my clients that kind of takes a long time sometimes to gather, but if you can pull together all of the different assets that you have, statements for your different accounts, everything that you can think of when it comes to assets. So checking, savings, money market, life insurance policies, 401ks, real property, all of those sorts of things that make up your entire estate. And then also a general idea of your plan and who you want the parties to be who are a part of that process. So in the event you're incapacitated, who do you want making decisions? In the event that you pass away, who do you want administering the estate, and who do you want to get it? Gotcha. I don't know if that's 5, but hopefully that works.
No, that's great. I mean, I really think people should get some of those tips and write them down, because again, it's really important for them to have that information. And Chelsea, so let's talk about, do you need a will to have a trust? Do you need a trust to have a will? Do they work hand in hand? And when the time comes, how do you get it started? So I think that's probably the last thing that people are thinking of, or maybe not, with some of the challenges that we have with those funny family members. But what, God forbid something happened to me or to my family member, and it's just devastating to think about. Is the process easy to get started, or how do you get started? So I know that's a layered question. So
sure.
Do they work in sync, and then how do you get started?
So to answer the first part of your question, they very frequently do work in sync with each other. Some things it makes more sense to take care of by virtue of a will, such as personal property. Perhaps some jewelry that is sentimental to you, or your car, or something like that may make more sense. It depends. Every situation is different. May make more sense to resolve through a will. And then other things like your house may make more sense to be in a trust. And oftentimes those documents will reference each other, and they will work hand in hand when it comes time to actually administer or carry out the wishes that are reflected in those 2 documents. As far as getting started with the administration, when that time does come, that's going to look really different depending on the provisions. With a will, we typically go through which Ashley was talking about a little bit earlier, the probate process, which basically means you go through the court. That can be a very seamless, easy process that you can do on your own. In fact, if you go onto the Maricopa County Superior website, and I'm sure many similar Superior Court websites, there are standard forms and a lot of good information on there. And it can be more complex and require what we call a formal probate, which requires a little bit more supervision and participation from the court system. So it's going to look a little bit different in every situation. One of the benefits of a trust, like Ashley mentioned earlier, is that you can avoid that process altogether. And the hope is that with a trust, you'll never have to go through the court system. It saves everybody money, hopefully is a little bit easier. Of course, famous last words, there's always issues that can pop up. When you're, and that's where we typically come in, or myself at least. Ashley helps people on the front end so that doesn't happen. And then if it does, I'm happy to step in. But in those instances, pardon?
I said, you're the cleanup crew.
Yes, yeah. How lovely, yes. No, yeah, we try to help people as seamlessly as we can through that process. But in the instance where we're talking about administration of a trust, the trustee, the person who's put in charge, will frequently, depending on the complexity of the trust, ask an attorney to help them, because when you're put in charge, you have a lot of responsibility. You owe obligations to other people. You want to make sure that you're not doing anything wrong. If it's a relatively, if it's a more modest trust or it's not particularly complex, it may not require that. But certainly if you're that person who's been put in charge, you want to make sure you're really comfortable and you understand what you're supposed to be doing. Certainly doesn't help to consult with an attorney in doing that, just so that you don't, bring on more trouble for yourself.
Gotcha. And here's two questions that kind of follow up on the aspect of things. If there's debt involved, how does that work? So, somebody may have a will, but they owe a debt. Does that come out of the estate or the will? How does that work? And then another part of that would be, okay, so I was named in the will, but I never got anything. And did I not get anything because there was nothing for me to receive? Or was there a glitch?
Sure. So creditors, people who are owed money, do have rights here in Arizona. And typically when we're going through the probate process with a will, the creditors will have to be notified that this will is now being submitted to probate, and they have a certain period of time to step up and assert whatever rights they believe they have. And the creditors look different. It's not always credit card companies or mortgage companies or those types of things. Sometimes it's individuals. Let's say you have been taking care of your parents' home and it was in disrepair and you've been fixing it up and getting it in good shape so that it could be sold. You may have a claim to be reimbursed for some of those expenses that you incurred on behalf of the estate to fix up this property. So that looks a little bit different, but certainly creditor claims can have an impact on the what everybody else is going to get. And likewise, if there are other distributions that are set forth, that can impact creditor claims. There frequently are times where there's just not enough left in an estate to pay everybody. That happens. So it's a collaborative effort. The main thing is that that there's transparency and everybody has access to information so that informed decisions can be made. So earlier, you asked me about somebody who is entitled to something under a will but hasn't received anything. That's a little bit of a red flag if they haven't been contacted and a probate has been opened. There should at the very least be some transparency, sharing of information. It's not always good information, but at least it's there and everybody can make informed decisions and determine whether this is something they want to invest time and money into or whether it's something that they're just okay to let lie.
Okay, good information. So we're going to start to wrap up, but I do have one more question from somebody that submitted it, and you guys can tag team this question. It says, a man knows that his father or grandfather altered his will, but doesn't have a copy of it and doesn't know the name of the attorney who handled it, has no details about the will whatsoever. So how do people research a will that they know or think exists? Where do they start?
Sure. Well, Arizona law requires a due diligence search. And so at a minimum, if you're going to be helping administer an estate, you want to make sure you explore all avenues. So that might include contacting other friends and family members. Maybe in this case, this individual knows the accountant that his grandfather used and could reach out to the accountant and see if maybe he had somebody, or maybe just a neighbor or a friend or a caretaker, somebody who might be familiar. So Arizona does request that people make good faith efforts to conduct a due diligence search, but it doesn't require that they go to the end of the earth trying to track down this document. And so at some point, it may get to a point where we're just not able to find this document that may or may not exist. Another resource, though, is you can certainly reach out to an attorney like Ashley or I, or somebody who practices in this area, because there are online resources and networks amongst trust, estate, and probate attorneys. And we will frequently see on message boards people posting, hey, I have a client who's looking for the will of so-and-so. Does anybody know anything about this? And so there's this little, this little network amongst the attorneys who practice in this area too. We try and help each other out and help each other's clients out when we can in that way. So that is another avenue to explore, but sometimes it's just some good old-fashioned digging and chit-chatting with neighbors and friends and that sort of thing.
Absolutely. Sometimes we make things harder than they should be, right? And
yeah.
No doubt that this time, death is not, anything to play with or to take lightly, but sometimes we just, the most obvious decision doesn't come to mind. So I get it. Ladies, any other tips? Any other resources that you want to share with folks? Anything that you think that we're missing? Any gaps? Let's share those now. Ashley?
Sure. I think, as I mentioned before, I think the power of attorney is just so important, but healthcare power of attorney, especially right now. There are resources on the AG's website where you can get at least a kind of a bare bones document going, so you have something if you don't have something currently. And so that's a big help through the state, that there are some documents available for you to utilize in that way.
Awesome. Chelsea?
Well, this might sound like a simple one, but Google can be really helpful in these instances. And I know a lot of times when people find themselves in a situation where a friend or a loved one has passed away and they're charged with these documents and they don't understand what they mean, and before they even want to call an attorney, they just want to understand what they're reading, because sometimes the language is, it's legalese, we call it, and it doesn't really make sense.
Yeah.
You can just Google some of these terms and then go to the Superior Court website, look at some documents. It'll just kind of help you familiarize yourself with this area and determine, is this something I can handle on my own, or do I, and I'm talking more about kind of after the fact, if you are helping with a loved one's estate, whether that means a will or a trust or whatever. But you can familiarize yourself with some of these terms. There's a lot of good resources online. I will say, though, you don't want to rely exclusively on Google. It just helps give you a little bit of context. And so then when you do get to the point where you're perhaps involved with the court or you're working with an attorney, some of these terms may have a little bit more meaning to you at that point.
Absolutely. Great information. So we're going to start to wrap up. Before I send you off to get busy, because I know that you guys are handling a ton of cases for your clients, I do want to thank you again for participating in this. Again, we want to be as helpful to the public during this time of uncertainty. So we truly appreciate you guys taking the time to help answer the questions that they've given us via social media. So thank you for that. I do want to also thank the Arizona Foundation for Legal Services and Education. They also filled in some of the questions that you answered for us. So I want to thank them for being a great partner with us in the Arizona Attorneys Respond social media program. So with that being said, I'm going to let the folks know that our next Attorneys Respond is going to be focused on bankruptcy. There's issues, because I know that with folks being furloughed, losing their jobs, not knowing if they're going to make their home, their mortgage, those questions are weighing heavy. So next week we'll have Attorney Claudia Lopez answering those questions for them. So if you don't have anything else, I want to thank you again, Chelsea, Ashley from TIffany and Bosco here in Phoenix. Thank you so much for the time that you spent with us today.
Absolutely.
Thank you. Thank you so much for having us. Stay safe.
You too. Stay safe.
Stay healthy.
And absolutely stay healthy and enjoy the rest.